Legal custody means that you are able to authorize medical care, educational care, entrance into schools, sign the kids up for camps, sign the kids up for, give permission for going on trips, anything like that. Legal custody has to do with the legal status of the child, and that primarily falls into religion, authorizing children to go to church, education, and medical treatment. It's primarily what it falls into. But there's many other things too. Special education needs, authorizing haircuts and ear piercing. It all falls under that category. The presumption in Minnesota is that joint legal custody is in the best interests of the child. So what the presumption means is that a parent that wants sole legal custody has to show why it would not be in the best interests of the child to share legal custody with the other parent. Physical custody, or primary physical custody, or sole physical custody, all of that is basically who does the child live with on a day-to-day basis. The trend in family law is to encourage the parents to decide on their own. If they are unable to decide, however, they first attempt to go to mediation, or hopefully they do. And hopefully a mediator will be able to talk to the parents and uncover a lot of times what the real issues and fears are. If that doesn't work, then a custody evaluation is started. And nowadays, with the lack of government funds, we don't really have custody evaluators associated with the counties. I think there may still be some, but that's dying away. So what happens is you hire a custody evaluator. There's no specific licensing or anything for a custody evaluator. Anybody can hang a shingle out that says custody evaluator. So most people have to trust their attorneys to select the custody evaluator. And hopefully your attorney is able to guide you and help you in choosing an evaluator. The parents are going to pay for this person. Custody evaluations, depending upon who's doing them, are going to range from $1,500 to $10,000. There's a wide variance. There's also a wide variance in competency of the evaluator. I do custody evaluations. A number of lawyers do. Psychologists do them. And lay people do them. Well, that's kind of old wives' tale in the sense that there is no statutory age. The law doesn't say, well, when children are 15, they can decide where they want to go. Because really, if they could, then they could decide to live on their own. They could decide to whatever. There are 13 best interest factors. The older the child becomes in real life, the more weight their preference is given. And late teenagers' preferences are considered very, very heavily. They are, sometimes they almost drive the entire case. They're not supposed to determine everything, but a 15, 16, 17-year-old's preference as to where they want to live will be given great weight. It's very difficult. Presently, the statute is designed to give children permanence. Therefore, what that means is, unless there's a compelling reason, custody or physical custody of a child should stay where he or she is. They shouldn't be flip-flopping all the time between the parents. That's not to say that joint custody is a whole nother realm, but you don't want to keep changing physical custody of a child. It's done in a two-part basis. The first one is you petition the court and say, here's what's wrong. and they take your affidavits as true. And if you have met what they call the nice Peterson standard, then you are granted an evidentiary hearing, and that's a trial. And then you have to show the court that what you said in your affidavits is true. You have to show that the child's physical or emotional environment where they're living endangers the child, physical or emotionally. You have to show that there's been a significant change in circumstance from the prior custody order. And once you have made what's called a prima facie case to the court that the child is in either physical or emotional danger and things have substantially changed since the prior order, then you also have to show the court why it's in the best interest of the child to change. There's a specific statute that now deals with move out of state. And there are certain statutory factors that the moving parent, if generally what this is going to apply to, or really this will apply to the parent that has physical custody, or frankly a joint physical custodian. There's some statutory factors that have to be met. If I recall correctly, there's 8. And it's a best interest standard, but it's a specific best interest standard designed to deal with moving. It's not unheard of for grandparents to have once a month visitation at all. It's also not unheard of for grandparents to have every other weekend. It really depends on the facts. The grandparent visitation statute is a statute that creates in some grandparents standing to seek visitation with their grandchildren. They have to be within a certain class. Then you have to show that it is in the best interest of the child to have visitation with the grandparent.